These are the top 5 civil appeals from the Ontario Court of Appeal for January of 2014. BENEDICT and OHWISTHA Capital Corporation is a case involving Aboriginal property rights. Under the Indian Act, Indians cannot give security on property that's on a reserve, whether that property is real property or personal property. The point of that is, in one sense, to allow or prevent non-Indians from taking possession of property that's on a reserve. But the effect, and perhaps the unintended effect of that, is to make financing very difficult for Aboriginals and Aboriginal businesses. The case involved a set of facts trying to get around those prohibitions. OHWISTHA Capital Corporation was a corporation that was not itself an Indian as defined under the Act, because it was a corporation, but it loaned $125,000 to Mr. BENEDICT for his fish hatchery business. Mr. BENEDICT, as what would otherwise be security for a loan like that, put up various farm equipment as what would be security for the loan. But what he actually did was give that equipment or sell that equipment to an employee of the OHWISTHA Capital Corporation, who then effectively bought that equipment by way of conditional sale. The loan was really to effect that conditional sale, and was all well and good until Mr. BENEDICT became insolvent, and OHWISTHA Capital Corporation took steps and realized on their security, which they weren't allowed to have. So they took the chattels, they took his farm equipment, and Mr. BENEDICT then sued in conversion for the Capital Corporation having taken his farm equipment. The Court of Appeal found that the tension between the purpose and the unintended consequence of the Indian Act was something that's obviously laudable to address. Unfortunately, in this circumstance, the transaction being a series of conditional sales that didn't accurately describe the transaction that took place, the Court of Appeal found that it was actually a sham, and so the Court of Appeal would not give effect to the particular financing arrangement that had been set up in that case. Shoppers Drug Mart and Beamish and his numbered company is a case about piercing the corporate veil. Shoppers Drug Mart had entered into a contract with a Mr. Beamish, who later incorporated a company to carry out the business, which was to pay utility bills. It was discovered by Shoppers that some of the money had gone missing and been misappropriated, and some of the utility bills were not being paid. Shoppers Drug Mart sued not only the company, but also Mr. Beamish personally. The Court of Appeal would not find Mr. Beamish personally liable for the mere fact that at the time he entered into the contract with Shoppers Drug Mart, the corporation didn't exist. The Court of Appeal held that as long as a corporation is incorporated after the fact, a reasonable amount of time after the fact, and actually adopts the business intended to be contracted for, that's okay. That doesn't expose Mr. Beamish to personal liability. But what did expose Mr. Beamish to personal liability in this case was the fact that he directed the company to do the wrong. He was the only shareholder, the only director of the company, and the wrongful acts that he caused the company to effect allowed the Court of Appeal to pierce the corporate veil and find him personally liable. Bombardier and AS Estonian Air. Bombardier had entered into business dealings with Estonian Air, which in turn was owned 90% by the government of Estonia. The business dealings fell through, and Bombardier sued not only Estonian Air, but also the Estonian government on the basis that the Estonian government had allegedly interfered with the business of the airline and Bombardier. Under the State Immunity Act, you can only sue a government if they have engaged in commercial activity. And the question in that case was whether that 90% interest in the airline was sufficient in and of itself to be that commercial activity that Bombardier could sue the government on. And the short answer in that case, on the facts of that case, was that it was not. TMS Lighting and KJS Transport is a nuisance case. It's not often a nuisance case makes it to trial, let alone to appeal. And the appeal decision is an interesting review of the law of private nuisance in Canada. The Court of Appeal upheld the nuisance finding, which I commend you to read, and However, the Court of Appeal couldn't understand how the trial judge came to damages, and it probably was the case that the trial judge took into account theories of damages that hadn't been properly argued before the trial judge. And so instead of ordering only nominal damages, the Court of Appeal ordered a trial, or in fact an assessment of the damages in the case. The Ontario Ministry of Labour versus Flexengate. The company was convicted of 2 breaches of the Occupational Health and Safety Act and fined $25,000 each. The JP ordered that the company pay them a total of $50,000, but on appeal, the Ontario Court of Justice found that the company had taken steps to comply with compliance orders and effectively rewarded the company by making both the fines concurrent, so ordering only $25,000 in fines. The Court of Appeal said that that was wrong in principle, that the company should not be rewarded for doing what it was otherwise obliged to do, which was comply with the Ontario Health and Safety Act, and reinstituted the full $50,000 fine. To read about any of these cases or to sign up for Lerners' monthly appeals Netletter, please go to our website at lernersappeals.ca.